Annyeonghaseyo. Welcome again to another lecture on persons and family relations. Our topic for today is conjugal partnership of gains. Okay, as you all know, conjugal partnership of gains is one of property regimes or marriage settlements that the parties can enter into before they get married. Okay, so it is also called relative community of property as opposed to absolute community of property. Relative, it is called relative because not all properties that you acquire before you get married are placed into a common basket. Okay, only those properties that you acquire by your effort, by chance, or after you get married, okay, are placed in the partnership basket. Okay? Unlike absolute community, wherein all the properties, no matter what the mode of acquisition is, whether gratuitous or through onerous or by efforts or by chance, all of them at the time that you get married, okay, becomes part of the community basket without distinction. That is why it is called absolute. Unlike in conjugal partnership, okay, only those properties that you acquire, no matter what the mode of acquisition, as long as they are acquired after you get married, of course, subject to certain exceptions, which we will discuss later, will form part of the partnership basket. That is why it is called relative. Okay. Now, the difference between absolute community and conjugal partnership is that in absolute community, there is no need to enter into any marriage settlement or property regime before you get married. In conjugal partnership, there is a need for the parties to execute a written contract or agreement stating that the conjugal partnership of gains will govern their property relations after they get married. So there is a need of a prior contract execution or signing, okay, for a conjugal partnership to be the regime of choice. Okay? Unlike absolute community, even if they did not execute any marriage settlement, the regime of absolute community automatically governs them. Okay. Now, why is it this way? Because Article 105 provides that in case the future spouses agree in the marriage settlements that the regime of conjugal partnership of gain shall govern their property relations during marriage, the provisions in this chapter shall be of supplementary application. Okay? Prior to the effectivity of the family code, it is the conjugal partnership of gains that is the default property regime. When the family code took effect, okay, the said automatic marriage settlement was replaced by the absolute community of property. Now, Article 106 defines for us what comprises the partnership properties. Okay, under the regime of CPG, in short, or for conjugal partnership of gains, the husband and the wife shall place in a common fund the proceeds, products, fruits, and income from their separate properties and those acquired by either or both spouses through their efforts or by chance. So meaning, the baseline, just like in absolute community, the baseline is the date of the marriage. So when you agree on conjugal partnership of gains as your property regime, after the marriage, all the income, all the gains that you will receive through your effort by chance, okay, shall become part of the partnership basket, as well as the products, fruits, and income from your separate properties. They will all form part of the partnership basket. Okay? And upon dissolution of the marriage or of the partnership, the net gains or benefits obtained by either or both spouses shall be divided equally. Okay? The conjugal partnership of gain shall be governed by the rules on the contract of partnership in all that is not in conflict with the code. So if you will recall, in absolute community, the suppletory applicable law is the provisions of the civil code on co-ownership. Okay? While in conjugal partnership of gains, the one which is of suppletory application are the provisions of the civil code on partnership. Okay. Conjugal partnership of gains is defined as one that is formed by the husband and the wife, where they place in a common fund the fruits of their separate property and the income from their work or industry. The same to be divided between them equally upon the dissolution of the marriage or the partnership. Okay. Uh, Okay, as I have said, what comprises the partnership properties? The fruits of their separate properties and those acquired by their efforts or by chance, as long as they were acquired after they got married. Those which were acquired by efforts or by chance before they got married remain to be their separate properties. But the fruits or income of those separate properties which were acquired by the spouses before they got married will go into the partnership basket. Only the fruits, the principal, remain to be separate property. For example, if you were able to acquire a land, or let's know, not a land, but a car, for example, when you were still single, because you have been working for several years before you got married, and you were able to buy a car from your income when you were still single. Okay, that car remained to be your separate property, even if you get married. Okay, however, if that car is rented, for example, or has been used for grab, for example, okay, the fruits or income which was generated from that car, from the grab use, will be placed in the partnership properties. But the car itself remains to be your separate property. So the one who owns it, the spouse who owns the car, can dispose of it even without the consent of his or her spouse. Okay? Now, what are excluded from from the conjugal, from the CPG? Okay, the following under Article 109 shall be the exclusive property of each spouse. That which is brought to the marriage as his or her own. So meaning, all the properties that you acquired before the marriage, that remains to be your own, regardless of the manner of acquisition, whether through your efforts, whether by chance, or whether it was given to you gratuitously, they remain to be your separate property. The baseline, the time baseline is the date of the marriage. Okay. So that number two, that which each acquires during the marriage by gratuitous title. So similar to absolute community, remember, if you acquired property, okay, after you got married, gratuitously, that remains to be your separate property. Okay? So if, for example, you received a donation after you were already married, even if, okay, the property is donated only to you, okay, it remained to be your separate property. Okay? Even if you acquire it after you get married. Okay? Number three, that which is acquired by right of redemption, by barter, or by exchange with property belonging to only one of the spouses. So meaning, if you have a separate property and you traded or exchanged that separate property with another property after you got married, the product of such barter of exchange or redemption, okay, will still remain your separate property, even if you acquired it after you get married. Okay, and last, that which is purchased with exclusive money of the wife or the husband. So if, for example, before you got married, you were able to save in a bank account, let us say 1 million. And after you got married, you decided to use that 1 million pesos in your bank account to purchase a house and lot, for example. Okay, that house and lot, even if you purchased it after you got married, remained to be your separate property. Why? Because the source of the fund that was used to buy that property remained to be your exclusive property. So what is important is the source of the fund. If it is sourced from your exclusive or your separate property, even if it is replaced by another property which was acquired after the marriage, that property remained to be your exclusive property. So those properties, the exclusive properties, these spouses who own them, the spouse or the husband or the wife, retained ownership, possession, administration, and enjoyment of their exclusive property. So they need not obtain the consent of the other spouse in order to mortgage, encumber, or even dispose of the said properties because they remain to be your separate properties. Okay? Article 111, a spouse of age may mortgage, encumber, alienate, or dispose of his exclusive property without the consent of the other spouse. Article 113 tells us that the property donated or left by will to the spouses jointly or with designation of their determinate share shall pertain to the donee spouse as his or her own exclusive property. In the absence of designation, share and share alike without prejudice to the right of accretion when proper. Okay, so this donation or leaving by will, donation or succession, these are properties which are acquired gratuitously during the marriage. So if it is acquired during the marriage, they remain to be the separate properties of the spouses. Now, what if the donation was made to them jointly? There is no designation of shares. Then it shall be divided equally between them. So the one half portion will be their respective separate or exclusive property. Okay? If the donations are onerous, the amount of the charges shall be borne by the exclusive property of the donee spouse whenever they have been advanced by the CPG. How about retirement benefits? Retirement benefits, pensions, annuities, gratuities, use of rocks, and similar benefits shall be governed by the rules on gratuitous or onerous acquisitions as the case may be. Okay. Article 116 provides the presumption, which is a presumption which is similar to absolute community of properties. Okay, remember that the baseline is the time of the marriage. So all the properties which were acquired by the spouses after they got married shall be presumed to be part of the CPG. Okay, just like in absolute community. Okay, so it is incumbent upon the person alleging that it is his or her separate property to present proof that it was indeed his separate property. So, for example, if a house and lot was acquired after the spouses get married, okay, but the money that was used to buy that house and lot came from the bank account of either of the husband, which he already saved even before he got married, then considering that it was the purchase price for the said house and lot came from a separate property, then it is removed from the CPG basket. But it is incumbent upon the husband to prove it that he used his separate money to buy the said house and lot for it to be excluded from the CPG basket. Why? Because there is a presumption that if you acquire a certain property during the marriage, that is presumed to be conjugal. Okay? So the following are conjugal partnership properties. This is the composition of the CPG basket. Those acquired by onerous title during the marriage at the expense of the common fund, whether the acquisition be for the partnership or for only one of the spouses. So if you used your efforts or if the manner of acquisition of a certain property during the marriage is onerous, okay, then that forms part of the CPG basket. Those obtained from the labor, industry, work, or profession of either or both of the spouses, your income, either from your business, your profession, your employment, okay, your part-time job, okay, um, they all belong to the CPG basket after you get married. Okay, the fruits, natural, industrial, or civil, due or received during the marriage from the common property as well as the net fruits from the exclusive property of each spouse. So all fruits, whether from the CPG property or whether from your exclusive property, all fruits will go to the CPG basket. Okay? The share of either spouse in the hidden treasure, which the law awards to the finder or owner of the property where the treasure is found. So even if you were able to acquire it by luck, okay, it goes to the CPG basket if the time of acquisition is after the marriage. Those acquired through occupation such as fishing or hunting, livestock existing upon the dissolution of the partnership in excess of the number of each kind brought to the marriage, and those which are acquired by chance, such as winnings from gambling or betting. Okay, however, losses shall be borne exclusively by the loser's spouse. So the thing to remember as to what consists the CPG properties is regardless of the mode or manner of acquisition, if it was acquired either through your own efforts, by chance, or by chance, okay, it remained to belong to the CPG properties. With respect to the fruits, all kinds of fruits, whether it came from the CPG properties or it came from your exclusive property, they will form part of the conjugal partnership. How about property which is bought on installment? If it was uh, bought on installment when the one spouse is still single, but it was paid when he was already married, to whom should said property belong? Is it to the CPG or does it remain to be his exclusive property? Article 118 answers that question. Property bought on installments paid partly from the exclusive funds of either or both spouses and partly from the conjugal funds belongs to the buyer if full ownership was vested before the marriage, and to the partnership if such ownership was vested during the marriage. So if it is on a contract to sell basis, Okay, if it is on a contract to sell basis, you started the installment when you were still single, and then after you got married, you were able to complete the said installment. So the deed of absolute sale was signed after you were already married, and that belongs to the CPG properties. But if you entered already into a deed of absolute sale, but with mortgage, for example, okay, so the deed of absolute sale already vested ownership in you when you were still single. Okay, in that case, even if it was paid after you already got married, then that remained to be your separate property. Okay. Article 119 tells us that whenever an amount of credit payable within a period of time belongs to one of the spouses, the sums which may be collected during the marriage in partial payments or by installments on the principal shall be the exclusive property of the spouse. However, interest falling due during the marriage on the principal shall belong to the conjugal partnership. Why? Because if, for example, you lent someone 1 million pesos when you were still single, payable at the rate of 10% per month, okay? And for a period of 2 years, okay? Let us say after 1 year, you already got married. There are still installments falling due at the time of the marriage. Okay, so if for example in the 1,500,000 plus interest was left to be collected, okay, that 500,000 remaining balance which fell due after you got married will still remain to be your exclusive or separate property. While the installments which fell due after the marriage will go to the CPG basket. Okay. How about if there are improvements made on the separate property after the marriage? So, to whom should the property upon which the improvements were made belong? Is it to the CPG or does it remain to be the exclusive property? Okay, the ownership of improvements under Article 120, whether for utility or adornment, made on the separate property of the spouses at the expense of the partnership or through the acts or efforts of either or both spouses, shall pertain to the CPG or to the original owner, subject to the following rules. When the cost of the improvements made by the CPG are more than the value of the property at the time of the improvement, the entire property shall belong to the CPG, subject to the reimbursement of the value of the property of the owner's spouse at the time of the improvement. Otherwise, said property shall be retained in ownership by the owner's spouse, likewise subject to reimbursement of the cost of the improvement. Okay? The charges and obligations of conjugal partnership of gains is similar to absolute community. So what are those charges that may be made on CPG properties? Of course, support of the spouses, consisting of food, shelter, clothing, transportation, education. The spouses and their common children and the legitimate children of either spouse. Debts and obligations contracted by both spouses jointly or by the administrator's spouse, okay, during the marriage. Okay? How about prenuptial debts? Debts acquired by the spouses before the marriage, insofar as they redounded to the benefit of the family, may also be charged to the conjugal partnership. Also, debts which have been contracted by only one spouse without the consent of the other, if they redounded to the benefit of the family. Government impositions, such as taxes, liens, charges, and expenses, okay, including major or minor repairs upon CPG properties. Taxes for mere preservation upon the separate property of either spouse can also be charged against the conjugal partnership properties. Okay, expenses for education of the children, for the self-improvement of their children, can be charged on conjugal partnership properties. Expenses of litigation, okay, unless the suit is found to be groundless, okay, can be charged to the conjugal partnership properties. Okay, so it is similar to absolute community. Payment of personal debts contracted by either spouse before or during the marriage shall not be charged to the CPG except insofar as they redounded to the benefit of the family. So there must be proof that the proceeds of the said loan contracted by either spouse or contracted prior to the marriage, okay, there must be proof that the proceeds of the said loans redounded or were used for the benefit of the family. Okay? Payment of personal debts contracted by either spouse before the marriage, that of fines imposed upon them, as well as the support of illegitimate children, may be enforced against partnership assets after the responsibilities enumerated in the preceding article have been observed. But at the time of the liquidation of the partnership, such spouse shall be charged for what has been paid for the purposes above mentioned, subject to reimbursement later on upon liquidation of the partnership. Okay, the rule insofar as gains in gambling and losses in gambling, okay, is the same as absolute, as is the same as absolute community of property. Meaning, all those gains will be part of the CPG, while the losses shall remain to be the loss of the spouse concerned. Okay, administration. The rule on administration of the CPG remained to be the same as that of ACP. Okay, what is that? It is joint administration. Okay, joint administration in case of disagreement, it is the husband's decision shall prevail, subject to recourse by the wife to the courts in case he feels that the husband's decision is not is abusive or there is abuse of discretion. The rule on donations for CPGs, the same as ACP. Okay, there in case of donation, both spouses must give their consent to the donation because it is a mode of disposition. Okay, they may make either spouse may make donations without the consent of the other, provided that it is only moderate on occasions of family rejoicing or family distress or to charitable institutions. Okay. Now, how is the CPG dissolved? The dissolution of the CPG, the grounds for dissolution, is almost the same as that of absolute community. Upon the death of either spouse, because if there is death of either spouse, the marriage no longer subsists. When there is a decree of legal separation, when the marriage is annulled or declared void, and in case there is judicial separation of property. Okay, what if there is separation in fact? Will it affect CPG, the regime of the parties for CPG? The answer is no. Okay, but the spouse who leaves the conjugal home shall have the right to be supported, shall not have the right to be supported if he refuses to live in the conjugal home without just cause. Okay, if there is a need to have the consent of the other in any transaction, judicial authorization shall be obtained. Okay, the separate property of both spouses shall be solidarily liable for the support of the family. Okay, what if there is abandonment? Okay, Uh, Abandonment has been defined as if one spouse has left the conjugal dwelling and no information has been received for a period of at least 3 months. Okay, if there is abandonment, you can file a petition for judicial separation of property because it is one of the grounds for separation of property or for the authority to be the sole administrator so that you won't need the consent of the absent spouse. Okay, how do you liquidate the CPG assets? It is the same as the rule on ACP. Okay, first you prepare an inventory of the CPG assets as well as the exclusive properties of each spouse. Okay, then you deduct the amounts advanced by the conjugal partnership. Okay, and then debts and obligations shall be deducted. Okay, then whatever remains of the exclusive properties of the spouses shall be paid to the spouse concerned. And then the net remainder after deducting the debts from the CPG assets as well as the charges on the CPG assets will be the net CPG assets. Okay, then the net CPG assets will be divided equally between the spouses. Presumptive legitimes of the common children shall be delivered. Okay, with respect to the conjugal dwelling, it shall be awarded to the spouse with whom the majority of the common children chose to remain. Okay, if there is, if they have the same children, then the court will decide. Okay, now we go to the cases involving conjugal partnership. Okay, we have Anastasio versus Coloma. The issue in this case is whether the CA erred in declaring that the subject property is the conjugal property of the late spouses Juan and Juliana. Okay. The petitioners argued that the respondents have the burden to prove that the subject property was owned by both Juan and Juliana, having made the allegation in the complaint. Okay, it will be recalled that the subject property was acquired in 1965 during the lifetime of the spouses while they were married. And it was registered in the name of Juan, married to Juliana. So the time element is very crucial. It was acquired during the time when the spouses are already married. So the property regime of Juan and Juliana was the CPG because it was prior to the family code. Okay, proof of acquisition during the marriage is a condition, prerequisite for the operation of the presumption in favor of the conjugal partnership. So what Anastasia versus Coloma teaches us is if the property was acquired after the parties were already married, okay, it is automatic that the presumption already operates, that it belongs to the CPG basket. So once the condition is established, the presumption that all properties acquired during the marriage, whether the acquisition appears to have been made, contracted, or registered in the name of one spouse or both spouses are conjugal remains until the contrary. So meaning, if you are alleging that it is the exclusive or separate property of one spouse, then you have the burden of proving the same. They had established that the property was acquired during the marriage of their parents. To overcome the presumption in favor of the CPG, petitioners were required to prove the contrary. Petitioners should have endeavored to prove their claim that the subject property was the exclusive property of one. So the fact that Juan and Juliana were separated from bed and board at the time of the sale by Juan to petitioners did not exempt the disposition from the requirement of obtaining the other spouse's consent under Article 116 of the Family Code. So Juan was not without any recourse. He should have gotten the required authority from the court. So once it is proven or once the presumption operates that it is part of the CPG, the disposition of CPG properties require the consent of both spouses. Okay? Without the required consent of the other spouse, then you could have gone to court and apply for authority to dispose a CPG property. Without that, the sale would be void. Okay, malabanan versus malabanan. Okay, because the uh, parties were married prior to the effectivity of the family code. Okay, the civil code shall govern their marriage. Under the civil code, property acquired during the marriage is presumed to be conjugal. What must be established is that the property was acquired during the marriage. Here, the evidence presented uh, by respondents were the burden of proving that the property was not conjugal were insufficient to overturn this presumption. Petitioner was then working in Libya, presumably earning income when the deed of sale was executed and the house was constructed. These circumstances, along with the execution of the deed of sale between Jose and Rodriguez and the title over the property being in Jose's name married to Melinda, sufficiently show that the property was indeed conjugal. So the sale of the conjugal property by a spouse without the other's consent is void. A contract conveying conjugal properties entered into by the husband without the wife's consent may be annulled entirely. Okay, so the as in all property regimes, consent of both spouses is needed for the disposition of either CPG properties or ACP properties. Okay, Villarama versus Uno. At the time of the marriage between Crisanto and Carmelita, it was prior to the effectivity of the family code. So it is the civil code which will govern. All property acquired during the marriage, whether the acquisition appears to have been made, contracted, or registered in the name of one or both spouses, is presumed to be conjugal unless the contrary is true. Credits are personal properties acquired during the time of the loan or other credit transactions was executed. Therefore, credits loaned during the time of the marriage are presumed to be conjugal property. As the deed of sale and promissory notes were entered into during the course of their marriage, the obligations thereunder are subsumed under their conjugal partnership. So if you will see the train of jurisprudence of the last three cases all points to the presumption that all properties that you acquired at the time of your marriage belong to the CPG basket. And it is incumbent upon the person alleging the contrary to produce proof that they are indeed the separate or exclusive properties of either spouse. Okay, Carlos versus Tolentino. Okay, Juan and Mercedes appear to have been married again before the effectivity of the family code. That is the reason why it is the civil code that governs them. And the civil code provides for CPG as their automatic or default property relation. Since the subject property was acquired on March 1967 during the marriage of Juan and Mercedes, it formed part of their CPG. It follows that Juan and Mercedes are the absolute owners of their undivided one-half interest. Okay? Upon Mercedes' death, it resulted in the dissolution of the conjugal partnership. Okay? So with regard to one's consent to the donation, it was lacking since his signature therein was forged. Okay, the signature of Mercedes in the donation was never contested and is therefore deemed admitted. So it cannot be ignored that Mercedes' consent to the disposition of the one-half interest remained undisputed. So it is apparent that Mercedes, during her lifetime, relinquished all her rights in favor of her grandson, Christoph. Okay, so the sale was upheld insofar as Mercedes' one-half share is concerned. So the right of Christoph as donee is limited only to the one-half undivided portion that Mercedes owned. The deed of donation, insofar as it covered the remaining one-half undivided portion, is null and void, not having consented to the donation of his undivided half. This is a stray ruling in the sense that the Supreme Court did not void the deed of donation despite the lack of consent of one of the spouses because one signature was forged. Only Mercedes' signature was genuine. So we can consider the Carlos versus Tolentino case as a stray ruling. Okay, we have Borlongan versus BDO. In Borlongan, the issue is the husband who was not a party to the suit but whose conjugal property is being executed on account of the other spouse being the judgment obligor considered a stranger. Okay, whether the obligation of the judgment debtor redounded to the benefit of the conjugal partnership or not. So in this case, one of the spouses was found guilty in a criminal case and was found also to be civilly liable. So can you enforce that civil liability, a judge against one of the spouses? Can it be charged to the CPG properties? Okay, there is no dispute that the contested property is conjugal. Payment of personal debts contracted by either spouse before or during the marriage shall not be charged to the CPG except insofar as they redounded to the benefit of the family. Conjugal property cannot be held liable for the personal obligation contracted by one spouse unless some advantage or benefit accrued to the family. So, if it is a debt contracted without the consent of the other spouse, or it is a liability, judgment liability, a judge against one of the spouses, there is a need to prove that it redounded to the benefit of the family. The proceeds of the debt or the proceeds of the crime must have been used for the benefit of the family. If there is no proof to that effect, you cannot charge it against the CPG properties. You have to charge it against the separate property of the guilty spouse. Okay. There is no presumption that the CPG is benefited when a spouse enters into a contract of surety. So in this case, the private respondent failed to prove that the CPG of the petitioners was benefited by the act of the husband in executing a continuing guarantee and suretyship agreement with the respondent. No presumption can be inferred from the fact that when the petitioner entered into an accommodation agreement or a contract of surety, the CPG was benefited. The private respondent was burdened to establish such fact. Okay, so considering that when the husband entered into a suretyship agreement, okay, there was no proof that the entering into that contract benefited the CPG properties, then it is not a valid charge on the CPG property. We now come to the case of PNB versus Reyes. So in this case, petitioner contends that the conjugal partnership should be made liable to the extent that it redounded to the benefit of the family. So this involves a loan secured by a mortgage. Okay, now for it to be a valid charge on the CPG properties, if it is incurred only by one of the spouses, there is a need for the bank to prove that the proceeds of the loan benefited the family. Okay, nowhere in the decision did the CA state that the principal obligation secured by the mortgage was void. Okay, there are two scenarios considered. One is when the husband contracts a loan to be used for the family business, and the other is when she acts as a surety. So in this case, the proceeds of the loan was used for a family business. In the former case of Borlonga, okay, the husband acted as a mere surety. Okay, if she is a mere surety, evidence that the family benefited from the loan should be presented. Okay, on the other hand, if the loan was taken out to be used for a family business, there is no need to prove actual benefit. So the law presumes that the family benefited from the loan, and therefore you can charge it against the CPG properties. Okay, the loan was used as additional working capital for the printing business. Since the loan money is used in the husband's business, there is a presumption that it redounded to the benefit of the family. Hence, you can hold the CPG properties liable. Okay, Labadia versus Luna. Uh, in this case, the marriage, there was a divorce which was obtained by Attorney Luna and Eugenia. Okay? In the said divorce proceedings, they also agreed, they entered into an agreement for the separation and property settlement agreement that they entered into before the court in the Dominican Republic. Okay, their purpose is to dissolve and liquidate their CPG properties. Okay, so however, the mere execution of the agreement by the spouses did not per se dissolve and liquidate their conjugal partnership of gains. The approval of the agreement by a competent court was still required. Remember the grounds for the dissolution? So you just cannot agree that you are dissolving your conjugal partnership of gains. Okay? The list provided for the dissolution of CPG, they are exclusive upon the death of either spouse, okay, when there is a decree of legal separation, when the marriage has been dissolved or annulled, etc., etc. And an agreement between the parties that they are dissolving their CPG is not one of the grounds provided under the family code for the dissolution of CPG. With the divorce being not itself valid under Philippine law for being contrary to public policy, the approval of the agreement was not also valid and enforceable under Philippine law. Consequently, the CPG of the spouses subsisted. We have the case of Pana versus Juanito. This case is about the propriety of levy and execution of CPG properties where one of the spouses have been found guilty of a crime in order to pay civil indemnity. Okay, so in this case, Melesha was found guilty for murder, and there was a corresponding civil liability imposed on the judgment. Can the CPG properties be held liable for the payment of the said civil liability? Okay, the Family Code itself provides in Article 76 that marriage settlements cannot be modified except prior to their marriage. The conjugal partnership of gains that govern the marriage between the spouses who were married prior to 1988 cannot be modified except before the celebration of the marriage. The husband and the wife place only the fruits of their separate property and incomes from their work or industry in the common fund. To automatically change the marriage settlement of couples who got married under the civil code into ACP would be to impair their rights to such separate property. Article 121 allows payment of criminal indemnities imposed on militia out of the partnership assets even before these are liquidated. So it may be considered as a valid charge on the CPG property, subject to reimbursement later on upon liquidation of the CPG. Okay. We have the case of Dewara versus Lamela. The issue in this case is whether the subject property is the paraphernal or exclusive property of Elenita, or is it the conjugal property of spouses Elenita and Eduardo. So the answer will define whether the property may be subject to levy and execution sale to answer for the civil liability adjudged against Eduardo in the criminal case for serious physical injury. So there is no dispute that the property was acquired by the spouses during their marriage. So the presumption will automatically apply that it belongs to the CPG. Now, if you are alleging the contrary, then there must be strong, clear, categorical, and convincing evidence. So aside from the assertions, however, of Elenita that the sale of the property by her father and her aunt was in the nature of a donation because of the gross disparity between the actual value of the property and the monetary consideration of the sale, there is no other evidence that it is indeed a paraphernal property. So it does not necessarily follow that it may automatically be levied upon to answer for said indemnity. Before debts and obligations may be charged against the CPG, it must be shown that the same were contracted for or the debts should have redounded to the benefit of the CPG. It is the spouse, if the spouse who is bound should have no exclusive property, if said property is insufficient, the indemnities may be enforced upon CPG assets only after the responsibilities enumerated in Article 161 are covered. Nevertheless, their conjugal partnership may be held accountable since Eduardo has no property in his. Okay? We have the case of Fuentes versus Roca. In this case, when Tarciano married Rosario, the civil code was still in effect. So while Article 165 made Tarciano the sole administrator of the CPG, Article 166, however, prohibited disposition without the other spouse consent. So in contrast to Article 173 of the Civil Code, Article 124 of the Family Code does not provide a period within which the wife who did not give her consent may assail the sale of the real property. Okay? Under the provisions of the Civil Code, a void contract has no force and effect. And this rule applies to contracts that are declared void by positive provision of the law. Although a void contract has no legal effect, even if no action is taken to set it aside, when any of its terms have been performed, an action to declare its inexistence is necessary. But here, Rosario died in 1980, the year after the sale. Does this mean that the right to have the said sale declared void is forever lost? The answer is no. The sale was void from the beginning. The land remained the property of Tarciano and Rosario despite that sale. When the two died, they passed on the ownership of the property to their heirs. Okay, since the sale was made without the consent of both spouses. Okay, we have the case of interdimensional VLT versus Shotchi. Okay, so this case involves the conjugal property of spouses Alfredo and Elvira. Okay, the sole administrator of the property was Alfredo. Okay, although he is the sole administrator, he still does not have the sole power to dispose. Okay, without the consent of the other spouse, the sale is void. Okay, the agreement entered into by Alfredo and Mario was without the written consent of the wife. Thus, the agreement is entirely void. Okay, we have the case of Kiao versus Kiao. Okay, Kiao versus Kiao defines for us the meaning of net profit. So upon the liquidation of the CPG properties, okay, and if there is a net profit that remains after deducting the debts of the partnership as well as the advances of the partnership, we now have the net profit. Okay. Uh, now, however, in Kiao versus Kiao, the court teaches us that prior to the liquidation, there is still no net profit because you do not know whether there will be a net profit unless and until the CPG is liquidated. Okay? Since at the time of the dissolution, the operative law is already the family code. The same applies in this case, and the applicable law insofar as the liquidation of the CPG is Article 129 of the family code. While one may not be deprived of his vested right, he may lose the same if there is due process, and such deprivation is founded in law and jurisprudence. His share of the conjugal partnership may be forfeited if he is the guilty party in a legal separation case. However, prior to the liquidation, the interest of each spouse in the CPG is inchoate. So the interest is limited is only to the net remainder uh, resulting from the liquidation of the partnership. So it is inchoate because you do not know uh, whether there will be a net remainder unless and until the CPG assets have been liquidated. Okay? Since it was already established that the spouses have no separate properties, there is nothing to return to any of them. Okay, no separate property which may be accounted for in the guilty party's favor. Okay, Soliano versus Soliano, that was already discussed in the separation of property cases. Okay, in this case, it was established or it was pronounced by the Supreme Court that you cannot dissolve a property regime by just a mere agreement. And you cannot enter into a complete separation of property through an agreement without the court's approval. There is always a need if you want to modify or shift your property regime to that of separation of property. You can do so, but you have to seek court approval first. Okay, Cordova versus T. Okay, in this case, there was a writ of execution to satisfy the civil aspect of a decision in a BP 22 case. Okay, now the petitioners wanted to exclude certain properties on the ground that these properties were allegedly para-personal, meaning exclusive, the exclusive property of one of the spouses. So the issue is whether or not the subject properties may be executed to satisfy the civil liability of cheating arising from the BP 22 case. Okay, the Supreme Court said in order to rebut the presumptive conjugal nature of the property, a movant must present strong, clear, and convincing evidence of exclusive ownership of one of the spouses. The burden of proof belongs exclusively to the spouse asserting it. So the registration of the property in the name of Teresita and the unilateral declaration made by Jean do not meet the clear and convincing evidence. While cheating directly received the money from the bounce checks, there was no showing that it was used in the business or in the exercise of his profession for the legal presumption that it redounded to the benefit of the family to apply. He was burdened to prove actual benefit to the family or the spouses. There is nothing on record which shows that the loans redounded to the benefit of the conjugal partnership. Okay, so that is the ruling in Cordoba. Okay, that you have to prove actual, okay, benefit to the family. Okay, to charge the CPG properties with the civil indemnities imposed on a judgment for BP 20. Okay, Alexander versus Escalona, a relatively new case, 2022. The spouses Escalona were married in 1960. Now they acquired unregistered parcels of land. George waived his right over lot number 1 in favor of his illegitimate son. Okay. Now Reagan and Belinda entered into a deed of absolute sale over the said real. Now the spouses Escalona filed a complaint for annulment of documents against Belinda and Reagan on the ground that Hilaria did not consent to the waiver of rights. The waiver of rights over a property which was acquired during the marriage. Okay. The issue is whether the properties are conjugal in nature. Okay. Belinda did not substantiate her claim that George exclusively owned the lots. Belinda failed to discharge her burden since bare assertion has no probative value. Any alienation or encumbrance of conjugal property concluded after the effectivity of the family code requires the other spouse's written consent or a court order allowing the transaction. Otherwise, it is void. Okay. The court holds that more than the date of the marriage, the applicable law must be reckoned on the date of the alienation or encumbrance of the conjugal property made without the consent of the other spouse. The alienation or encumbrance of CPG properties without the wife's consent made before the effectivity of the family code is not void, but merely voidable. Okay, the applicable laws are Articles 166 and 173 of the Civil Code. Okay. The alienation or encumbrance of conjugal property without the authority of the court or the written consent of the other spouse made after the effectivity of the family code. The applicable law is Article 124 of the Family Code. Okay, unless the transaction is accepted by the non-consenting spouse or authorized by the court, an action for declaration of nullity may be filed before the continuing offer on the part of the consenting spouse and the third persons become effective. So in this case, Reagan and Belinda did not show any vested right over lot number 1. Hence, the applicable law is Article 124 and not the Civil Code, which renders void any alienation or encumbrance of conjugal property without the consent of the other spouse. So that's it for conjugal partnership of case. Thank you for listening.